Using Google and Google Scholar to do legal research. Hi, okay, today what we're going to do is we're going to show you how to find cases that are useful to you in whatever research you're doing, okay? So for today's purposes, what we're going to do is we're going to find a good case law that we could maybe model our situation on or our arguments on in bankruptcy regarding student loans. And for today's purposes, we're going to pretend that we live down south in my hometown, Atlanta, or in Georgia, in other words, in the 11th Judicial Circuit, okay? So what we're going to do is we're going to look up bankruptcy cases and see if we can find a good one in Georgia or in one of the 11th Circuit cases, okay? So how do we do that? We go to Google Scholar, and we are going to, as soon as this comes up, we're going to do case law, and we're going to select courts, right? Because we don't want every federal court, although for later purposes, if you're looking for a sample and you can't find a good one in the 11th Circuit, you could maybe try all the federal circuit courts. Okay, we're going to select courts. We're going to select federal courts. And there aren't any selected right now, which is good. If there were some selected, you would simply go back here and clear all. And now we're going to find the 11th Circuit down here. And notice that when we click on 11th Circuit, all of the courts, Court of Appeals for Alabama, Florida, Georgia, they all show up. So we're going to find a case in any of those particular jurisdictions or the Court of Appeals itself, okay? And that's really what we're looking for, ideally, is the Court of Appeals. Now we go back up here and click Done. Okay, and now we're going to say bankruptcy and student loans. We don't have to say and. Student loans. And now this should find cases only in the 11th Circuit when we click on the little search thing. And it does, okay? So now what we're going to do very quickly, because I want to get down here and see. Okay, so let's take a look at N. Ray Cox. That's just the first one up. Okay, so we're see the bankruptcy court ordered a partial discharge, but we don't know whether this court, the bankruptcy court, was affirmed. If it was, it's probably a good case. If it was not, probably not a good case. Okay, so we click on that and we come to this, and now what we want to do is we're going to look at the introduction. Okay, and this case happens to be the case where the 11th Circuit adopts Bruner. That's always a bad sign, but here in that, Bruner is the authority for the 11th Circuit. Okay, so they agree with the district court's conclusion that Cox will suffer no undue hardship in repaying. So that suggests this is not going to be a good case. So we're going to pass that up. We could look, if we have some cases that we want to, distinguish our case from Cox. We would have to look at that. So now let's go and take a look at Mosley. And we're going to see that this was again a case where the student won, the ex-student, right, won because the educational people are appealing, and it was the bankruptcy's order discharging this guy's student loans on the basis of undue hardship, and they affirm. So that means that they're going to apply, they're probably going to apply Brunner in a way which is beneficial to us, okay? So that's likely to be a good case. Now here we start with the facts. And we have the guy who, he hurt himself while at school. And let's see, in 93, yeah, so he was still at school. Okay, he left the school, and then he couldn't go back to school, but he couldn't, because he had debts which he hadn't paid for, and so he couldn't go back to. And he declared bankruptcy and got the other debts discharged, but not his student loans. Okay, so now he's got mental health problems, as you can see here. Diagnosed with anxiety and depression. He was committed by his mother to the hospital, so that means bad things. Now he's also got back pain, swelling, high blood pressure. So the guy is in bad physical shape. Do we see how much his loans were? Yes, here they are. His loans total approximately $45,000 and have been in default since 1996. No payments since then. And let's see. So, of course, in a situation like this, where the guy is, half dead and hadn't been employed for 8 years, the student loan people are going to attack his ability to get bankruptcy release, right? That's fairly typical of cases like this. Now I want to just go down, and we're gonna. You could see these are facts regarding Mosley and the case. We're probably going to say and you can see here that this circuit has joined others applying Brunner. Okay. And so they're going to apply this test. Minimal standard of living, 1. 2, additional circumstances suggesting it's going to continue that way for a long time, a significant portion of the repayment period. And 3, good faith efforts to repay. Okay, so those are the tests that Mosley's going to have to show. But we know that Mosley hasn't paid for a long time, so that's going to be an issue that he had to deal with, right? Clearly, the guy has no money. He's got long-term mental problems. So we start with the first requirement, minimal standard of living. That's covered. All right. Now let's go down and see if we can see what they did on the second. Several illnesses likely to impair the ability to repay the loans. The educational credit argued that he had to have medical evidence, that is from an expert, in order to make the showing of those extra circumstances that would make it impossible for him to pay. Now, the critical thing about that is that where medical evidence means official testimony by doctors who are expensive. You couldn't get medical evidence for under a couple of $1,000s at least, okay? Luckily, the Sixth Circuit has rejected this argument, and it looks like the 11th Circuit is going to reject that too. And let's just say that they do decline to adopt the rule that requires medical evidence by experts, which is good because that means it's possible for pro se people without much money to get it, to testify about their own circumstances and to show records that they've got. And we're going to move on now because we know that we know he won this argument, right? I want to take a look back here at the good faith question, okay? Okay, let's take a look at the good faith. Okay, here we go. Down here, at page 1327 of this 494F 3rd 1327, we have the final Bruner requirement, the good faith efforts. Now, he hasn't paid since 1996, but the 11th Circuit has found that failure to make a payment standing alone does not establish a lack of good faith. And they cite the 10th Circuit, this Polly's case, which is really good for people in the 11th Circuit. Okay, so you don't have to have made payments if you couldn't afford them. Okay, and so they say instead, here's the test that they adopt for good faith, okay? Measured by a debtor's efforts to obtain employment, maximize income, minimize expenses. His default should not result, it should result from, not from his choices, but from factors beyond his reasonable control. So poverty, if that keeps you from making payments, won't stop you from showing good faith, which in many jurisdictions and in a lot of the old cases, it simply did, okay? But not in the 11th Circuit. So this is a good case for us as far as that's concerned. And now, they said that he had to, here's another one, that he was supposed to negotiate a repayment plan under the Income Contingent Repayment Program, the ICRP, which extends repayment periods to as much as 25 years, okay, or seek an administrative discharge. So the 11th Circuit is going to reject that rule just because you didn't sign up for the ICRP. They reject that because if you aren't going to have to make any payments under it, they reject the idea that you have to submit yourself to 25 years of debt hanging over your head. And let's see, I think they may also find that the tax results are also a bad thing. But that's, in any event, many of the cases that have examined that question and come up with the right ruling have found that the tax consequences are something that would prevent you from having to sign up for the ICRP, okay? So let's see. I think we're just gonna stop here and keep this a fairly brief video. So as you know, as you can see, this is a case where you know, the 11th Circuit did the right thing. You may not be, and I hope you're not, in such terrible shape as this guy, but if you can show that you don't have money and really, you know, haven't had a reason to have money in the view of the court, you may be able to show the good faith. And the other things you're going to want to show that your situation could or is going to or has lasted for a long time, and basically through no fault of your own. In this case, we're talking about medical conditions. So if you don't have a medical condition, you're probably going to want to look for another case that has some other things going for it. But if you've got a severe medical condition, this is a great case for you because you can use it to quote. Now, one of the other things, a couple of the other things are that the fact that you haven't made payments for a while or even ever is not going to be dispositive. That is, it's not going to, you know, end your case on the Bruner case, which is a good thing. And then the other thing is the ICRP. You don't have to sign up for that. And so that means if you're in the 11th Circuit, you need to be really careful about whether you would sign up for the ICRP. Okay, so we've found a good case. Now, what we would do is we would simply copy it or take the, get the URL so that we could do that, and then we would go looking for more. Okay, so to recapitulate, we first went to Google Scholar and selected the jurisdiction we wanted. We might have tried a Google search, but as it turns out, we wanted a specific jurisdiction, the 11th Circuit. And so we know that that's an option that Google Scholar has and Google itself does not. So that's why we went to Google Scholar. We put in our search term, and then we glanced at the little blurbs which describe the cases on the search results. We didn't find that those descriptions were very helpful in the case of bankruptcy and student loan discharge, but in many kinds of cases they will be quite helpful, just not in these. Okay, so then we went to one of the cases, we clicked on it, and we checked. We didn't like that first one because it was, I can't remember whether it reversed the student loan discharge or it affirmed a rejection of the student loan discharge. Well, we didn't like it. It didn't it didn't appear to be a good case for us. So then we checked out another one, the second one, I think, and that was a good case. We looked at that one more closely, noting the arguments and points of law that were beneficial to our position. Then we also took a close look at the facts of that case for purposes of either comparing our situation as it already exists to that case or for modeling for future in case we want to make, if we have time to adjust our circumstances a little bit, we would want to make our facts look more like that case. One step that we didn't do in the video, but that you will want to do if you are taking your research seriously, is to click on the How Cited button on that first page of the case for Google Scholar to see whether other cases are using the case, and they'll be quoting things, and that'll give you an indication of what facts other courts think are most important. So that will give you some sense of which facts you would want to emphasize. Our next step then is to go back and do it all over again, because you can't just stop with one case. You have to get a number of cases so that you get a fuller appreciation and understanding of the important facts and the way the courts in the jurisdiction that you are selecting use them. If the jurisdiction that you've selected does not have cases which are helpful to you, then you would want to try it other jurisdictions. In this particular case, the court cited a 10th Circuit case called Polly's very favorably, and so that would indicate that anything in Polly's is probably helpful to you, and cases that cite Polly's are probably going to be helpful as well, although you want to be a little bit careful about that because the courts of the 11th Circuit don't necessarily follow the 10th Circuit rulings. Okay, so that's just, but that'll be something that is an indication when a Circuit Court of Appeals quotes another Circuit Court of Appeals favorably, then it suggests that the facts of that case, of the quoted case, are important, and other cases which are interpreting it could also be considered important. If you are in court, worried about going to court, or think you should go to court but can't afford a lawyer or don't know what your rights are, you should join us at yourlegallegup.com. Debt collection is a social justice issue. Take action to protect yourself from the debt collectors and help others do the same. Please like this video, share it with anybody you think could use it, subscribe, and comment, as all of these things help others find our materials. yourlegallegup.com.